All right. I see that we have many that have joined. Let's go ahead and get started. So my name is Brian Calley. I'm the CEO of the Small Business Association of Michigan. Thank you so much for joining us. We have a really important topic today, the Corporate Transparency Act. So this is an act, a new federal law that went into effect on January 1st, and we've got some legal action that we want to share some information and insight with you about. So let me go and just kind of set some ground rules. Sarah's keeping track of the chat throughout this, and at the end, with questions and things that come up, we'll see if there's any themes and things that didn't get addressed throughout the presentation, and we'll try to address those toward the end of the presentation. But this is actually about the legal action, so it's not this really isn't the type of webinar for, like, here's the situation in my business. Do I need to file file on this particular employee within my business? I mean, those types of particular fact-based questions, probably not for this webinar, but we do have that resource page, and we do anticipate putting on additional webinars for those types of questions. Today, what we're really trying to do is to let you in on what's happening with the legal action. So we've got a great team of attorneys that are with us here today from Miller Johnson. So I want to start with some introductions. They're handling the lawsuit against the IRS and FinCEN for SBAM and our co-plaintiffs. So let me throw it over to Andrew Portinga. Andrew, maybe just start out with an introduction to the team.
You bet. Thanks, Brian, and good morning, everyone. My name is Andy Portinga. I'm a litigation partner at the law firm of Miller Johnson. I specialize in federal court litigation. I have been the president of the Federal Bar Association for the Western District of Michigan, as well as the chair of the U.S. Courts Committee for the state of Michigan. On my team with me is Steve Van Stemford. Steve is a specialist in appellate litigation and in federal court litigation, and he has briefed and argued a lot of interesting constitutional issues in the Federal Court of Appeals and in the United States Supreme Court. The third member of our team is Eric Daly. Eric is a member of our corporate law department. He has been following the Corporate Transparency Act since its inception in 2021 and has become a subject matter expert in the statute and the regulations under the statute.
All right, very good. Well, thanks for the introductions, and let's start with Eric. Eric, you, having really dug into this and helping clients with compliance, know the ins and outs of it. And I think it would be good for us to start with a level set in the audience in terms of what is the Corporate Transparency Act. Don't want to assume that people know about that. In fact, it's pretty common when I'm talking to a group of business owners and I bring this up that it's the first time that they've ever heard of it. So let's start out with, what is the Corporate Transparency Act? But also, please, a little bit of insight into why it's so problematic.
Yeah, absolutely. And thank you, Brian, and the team at SBAM for hosting this webinar. It is an important topic. We'll keep the background relatively brief so we can focus more on the litigation. But as you said, Brian, just to provide a level set so folks have the overall context, the Corporate Transparency Act was included in the National Defense Authorization Act in late 2020. And that NDAA is considered really must-pass legislation each year. It includes appropriations for defense and national security, and sometimes things like the CTA find their way into must-pass legislation, even though they might not in and of themselves have the same level of support to be enacted into law. And so the Corporate Transparency Act sort of fits into that category, where in late 2020, as the National Defense Authorization Act was coming together in its final form, a piece of legislation, the CTA, that Congress had tried to pass without success a number of times previously, was incorporated into the NDAA. And the goals of the CTA, I don't think many people would object to. It's really things like trying to prevent financing of illicit activity or money laundering, things like that. However, maybe because of the way the law was passed, it didn't get the level of scrutiny or examination about how it would be implemented in the way we might have liked. And so you end up with a new piece of legislation that the Financial Crimes Enforcement Network, which is sometimes called FinCEN, it's part of Treasury Department, is required to implement over the course of 2021 and 2022. And this happened. This is what you were referring to over the past couple of years, where we've been tracking the CTA and the rulemaking. So Treasury Department went through a process of saying, here's what needs to be disclosed by companies that are not exempt from the Corporate Transparency Act's requirements to disclose information. This would be basically applicable to any entity either formed in the United States or formed in an outside jurisdiction, a non-US jurisdiction that files to conduct business in the United States, unless it gets the benefit of an exemption from reporting. And those exemptions generally apply to large businesses that may already have some level of federal regulation or oversight. So if you think about publicly traded companies, banks, financial institutions of different sorts, insurance companies, these are the types of entities that kind of get a pass under the CTA and don't need to report anything. It's really the companies that are smaller private entities that are not highly regulated that feel the impact. And it's estimated that there are about 30 million or so of these entities already in existence heading into 2024, which is when the CTA went live on January 1st of this year. A little over 30 million entities that are subject to the CTA and not exempt. And a great many of these are really small businesses. And in the sense defined by the CTA, a small business is an entity that has either 20 or fewer employees or less than $5 million in gross receipts reported to the IRS in the prior year. So you have to be over both of those thresholds, more than 20 employees and more than 5 million in gross receipts in the prior year reported to the IRS in order to be exempt from reporting, to be considered a larger operating company and not have to report your information to FinCEN. The type of information that you need to report, again, assuming you're not exempt, would basically be for every beneficial owner of your company. And here we're talking about actual human beings, not reporting just we have a shareholder who is itself an entity and we're going to stop the inquiry there. You really have to look through those companies, or if you have a trust who's a shareholder, look to see who the trustee of that trust is and figure out every actual human being who arguably has substantial control, which Steve and Andy may get into is a pretty open-ended and vague concept under the statute, or satisfies a number of clear-cut requirements for ownership, like 25% ownership or 25% voting power. And in those cases, there will be sort of de facto control and reporting. So just kind of to wrap up and let Steve and Andy pivot into the litigation and some of the obvious ways maybe in which this is problematic. Non-compliance with the CTA is not just necessarily a slap on the wrist. There are criminal penalties potentially associated with willful violations that could include jail time in an extreme case. And there may not be mechanisms for companies who are subject to the CTA to kind of get the information that they need in order to report, right? You may not have any way to compel a shareholder to give you all the information that's required to comply with the reporting obligation. So these are just a few of the ways in which the CTA is problematic for small businesses and has been implemented in a way that really puts the onus and a lot of pressure on those reporting companies to get information that they may not have ready access to, and which the people who provide it may not have ever envisioned disclosing to the company, let alone to the federal government. So I'll pause there.
Yeah, thanks, Eric, for the overview on that. And a few things that really stuck out to me is that, first of all, it was stuck in another act because Congress really couldn't, as a standalone bill, they were unsuccessful in getting it passed. So they kind of put it in a bigger bill that had to pass, and it just kind of like trailed along with it. And I think that's one of the reasons why so few people even know about this. I wonder how many people in Congress that voted for it really knew or understood about it. But also there's this concept of owner, and you'd think, well, owner, there's 25% or more ownership. Seems pretty cut and dry. Why is it that so complicated? But it doesn't necessarily require that the person owned the business, but they have substantial control. And that is when you throw criminal penalties in, the idea of substantial control that's not tied to formal ownership being a thing, and then the personal information and not being able to require those substantial or the beneficial owners to report it really puts business owners in a tough spot. So we filed a lawsuit in the Western District in Michigan, federal court. And Stephen is the lead on that. Stephen, could you give us a rundown of this lawsuit? There's some really important constitutional questions at stake.
Yes, thank you, Brian, and thank you everyone for having us on. And it's a pleasure to represent SBAM and its members in this litigation. We think it's an important piece of litigation. And we're glad to be working on it for you and with you. So we did file a lawsuit in the Western District of Michigan, as Brian mentioned, on March 26th. We filed that on behalf of the Small Business Association of Michigan, as well as some individual plaintiffs, as well as the Calley Chamber of Commerce. And we filed our complaint, and we had a couple of claims in there, which I'll get into in a second. But at the same time that we filed the complaint, we filed what's known as a motion for preliminary injunction. And in that motion, what we're asking the court to do is to prevent the federal government from enforcing the provisions of this statute against the Small Business Association of Michigan's members and the individual named plaintiffs. So the idea here is, if we prevail, we're asking the court to prevent the federal government from requiring these disclosures. Now, as Eric mentioned, right, the main gist of the CTA is these compelled disclosures, includes passport photos and other information of all these beneficial owners. And we have a couple different theories about why this is improper for the government to request. So first of all, our first argument is that that Congress simply didn't have the power to pass it, right, to enact this legislation. So Congress has some enumerated powers in Article 1. The most often implemented or most often used is the commerce power. Congress has the ability to regulate interstate and foreign commerce. And we have an argument that is essentially this, that Congress can't regulate activity that is not itself economic, and it can't regulate activity just on the basis that at some future point these entities or individuals will engage in commerce. So because what happens here is that the CTA, it's triggered by merely the fact that an organization exists, right? So it applies to any organization that is created through a filing with a court or with a state office. And so what it's doing is it's regulating organizations merely on the basis of the fact that they exist. And our argument is that that's simply improper underneath the Obamacare decision from the Supreme Court several years ago. And that argument was actually accepted in another federal court down in Alabama. And I think Andy will talk about that briefly.
Yeah, and it really did put a finer point on that too. I mean, just so, because I think a lot of our audience can understand this. You form an LLC or some, some sort of a business entity, and you haven't necessarily even done anything with it. Yeah, but the Corporate Transparency Act requires, just because you formed it, no commerce has been conducted yet, just because, and maybe never will be, because you formed it, now you have to report. And so there's no enumerated power for Congress. They can't really point to the Commerce Clause, or at least that's our argument here. You can't really point to the Commerce Clause because the reporting is triggered by something that doesn't even presuppose commerce has happened in the first place.
Yeah, exactly, Brian. So you could create an LLC, for example, and just put it on the shelf, not do anything with it, don't have any assets, no economic activity. The CTA would still require disclosure with respect to that business, even though it hasn't done anything except exist. And so that's the basis of the argument there. And again, that was accepted in federal court in Alabama, as we'll discuss briefly. There are also the government also has argued that, that the CTA is authorized by, or is a proper exertion of Congress's power over foreign affairs and national security powers. That argument, however, we think, basically the government is just saying, look, we have these amorphous ability to, legislate in favor of resolving national security problems. But the CTA is in a class of its own, right? It's a domestic facing regulation. And, when you look at the case law and you look at the precedents, there's really not a whole lot to support the government's argument in that respect. And then same, they may also make this argument that it's a exertion of the taxation power. But again, there's pretty scant authority for that as well. So that's the first basis of our challenge, right? The first basis is to say, look, Congress doesn't even have the power to do this in the first place because of the specific way that they determined to draft the legislation and why it's triggered. Now, the second argument is, okay, well, even if Congress had the power, right, it violates the Bill of Rights. So we have a Fourth Amendment argument, and the argument there is that what's happening is that the government is compelling information from law-abiding business owners, law-abiding citizens, without any reasonable suspicion of wrongdoing. That compelled disclosure, right? And they're compelling it under threat of felony prosecution. They're compelling that information under threat of prosecution, but they're also compelling it for the sole purpose of seeing whether people are involved in crimes and criminal activity. So it is a compelled disclosure from individuals and entities directly to law enforcement agencies. Now, ordinarily, you can't have a search, a government search, if there's no warrant, right? You have to have a warrant, you have to have reasonable suspicion, you got a probable cause that there's actually criminality involved. The government ordinarily can't just go around and force people to disclose stuff. And so that's our argument on the Fourth Amendment piece, is that this is an unreasonable search because it's demanding information to be delivered directly to law enforcement agencies, law enforcement officers, without any reasonable suspicion. Now, the government may have some various arguments to make, and we'll deal with that in the lawsuit. But it is interesting because one aspect of the CTA that not a lot of people know is that the information can go directly to what's FinCEN, right, which is the Financial Criminal Enforcement Network. And then that organization can then hand that information off to other federal law enforcement agencies if they ask for it. But it can also hand it off to foreign governments, right, foreign governments who request the information from federal agencies and FinCEN. And so,
and Stephen, if I remembered or read it correctly, that it doesn't even require, the information can be shared without a warrant, without some sort of court order, just at the discretion of the agency. They create this huge cache of information on tens of millions of business owners, and then they can essentially use it for investigations, including handing it over to other agencies. You could really get the sense for if there's a dispute, and a lot of our business owners will understand from time to time you have a dispute with the government. And the idea that this is one more leverage point where they can look and say, oh, one of your beneficial owners changed addresses last year and you failed to report that address change. Well, so we're going to stack this up on their grievances. Or if you just want to settle this issue with us over here, perhaps we can let this go. I mean, the idea that not only is it collected, not only is it collected for the sole purposes of warrantless criminal investigations, but also can be shared with any other entity without a judge even being involved.
Yeah, that's exactly right, Brian. So, you know, ordinarily, there are certain exceptions to the warrant requirement. You can have what's known as an administrative search, for example. But even in those instances, ordinarily to be constitutional, to be appropriate, there has to be some independent or neutral oversight, right? Whether it's a judge or some other neutral arbiter. And here there's none. Right. I mean, you know, if you, especially for sharing information with other federal agencies and then to foreign governments upon request, there's no court oversight built into the statute. So, in other words, this information is being compelled from American citizens and then can be shared with law enforcement agencies and, you know, foreign governments around the world upon their request if the federal government deems like it chooses to do so. So those are, I mean, there's a lot more, you know, complicated arguments, but, you know, that's the overview of the Fourth Amendment claim. And then the third kind of angle, or the third argument we have is a Fifth Amendment claim, actually, and it's a due process claim. There's a very well established doctrine in constitutional law that says if a statute is vague, right? If ordinary people can't figure out what's actually required or not under it, then it can be unconstitutionally vague. And that concern is heightened when there are criminal penalties. And here, of course, there are criminal penalties. There are potential felony liability. And the statute, when you look at it, and even when you have the regulations layered on top of it, the regulations don't really help, you know, determine who has substantial control. For example, the regulations that FinCEN promulgated, in part, they define substantial control as meaning substantial control. So that's a circular definition, doesn't really help solve the vagueness problems. So we've outlined in our complaint and in our brief in support of the preliminary injunction motion the different ways in which the statute is really, you know, really difficult to understand. It's really difficult to understand from the text of the statute who can be prosecuted under it, whether the entity can be prosecuted or whether the individual beneficial owners can be prosecuted under it. So there are a host of problems with that, and that is the third kind of wing of our argument. So without going into too much detail there, I can leave it there, Brian, and we can talk about the Alabama case if that makes sense.
Yeah, absolutely. In fact, I just seeing a few questions coming in, and one of them, I think, Andrew, that you'll address, because there is a what I consider to be kind of like a sister case, if you will, a similar case that that's originated in Alabama, is now in the 11th Circuit Court of Appeals. And so maybe if Andy, if you could just let us in on both, you know, what's going on in that case, but also why it's important that that we don't put all our marbles in that one basket.
Sure, you bet. So as Brian and Steve mentioned, there is a very similar case pending in the 11th Circuit Court of Appeals right now. The 11th Circuit governs Florida, Georgia, and Alabama. The appeal is from a ruling of a judge in the Northern District of Alabama in a case that is very similar to ours. In early March of this year, I think it was March 8th, if I recall, a judge, March 1st, actually, a judge in the Northern District of Alabama ruled that the Corporate Transparency Act was unconstitutional. And that judge ruled that Congress did not have the power under Article 1 of the Constitution, under either under the Commerce Clause or under the Taxing Authority or under the Foreign Powers Clause or any other authority to enact the CTA. Because the court ruled on that grounds, on the Article 1 grounds, the court did not address the Fourth Amendment or the Fifth Amendment arguments, which we are raising in our lawsuit. The plaintiff down there did raise those same issues, just the court didn't address those issues. So how does that relate to us? Well, that opinion in Alabama applies only to the plaintiffs in that lawsuit. And so that was National Small Businesses United, as well as a few individual Alabama entrepreneurs. And businesses. So it was not a nationwide injunction. It does not state enforcement of the act for everybody. It only applies to the plaintiffs there. The government has appealed that decision, and they asked for expedited review in the 11th Circuit. The government filed their brief yesterday in the 11th Circuit. The plaintiff's brief is due in a couple weeks, and I anticipate that there'll be argument in that case probably later this summer, perhaps early fall. There is one other lawsuit that was filed in the District of Maine that was just recently filed, and nothing really has happened there. So there are similar lawsuits going on around the country on the very same issue.
All right, very good. Well, I appreciate the insight and the expertise, and I think what would be good because we've got several questions here, and I think they're they're interesting and relevant. Let's go ahead and start going through a few of these questions that have come up. So the question with respect to the case in Alabama, it was ruled unconstitutional. So how does ours compare? Very, very similar arguments. So we've made similar arguments. Actually, the government's response was very, very similar as well. So so the basis is similar, but I think there's an important distinction, which is that, as you had mentioned, Andy, that in Alabama, that case was really decided on the enumerated powers issue, and the other important constitutional questions have not even been addressed yet. And and correct me if I'm wrong, but we think that as we go down the stretch here, Court of Appeals, ultimately maybe the United States Supreme Court, the decision will probably rest on something other than enumerated powers.
Yeah, I think it's certainly fair to say that there are a number of judges who are skeptical of sort of the broad nature of Congress's powers that has existed since the New Deal. I don't know if that's a majority of judges today or not. I do think the issues under the Fourth Amendment, search and seizure, and under the Fifth Amendment are also very important issues that will appeal to a lot of judges across the spectrum.
Absolutely. So there's a question also came up too. It's an interesting one. Don't banks collect beneficial owner information at account opening, or is it just certain banks and there are certain gaps? And I actually am a recovering banker myself. I was a banker for many years, and there has been a requirement for a long time in banks to report, but it's a finite and very well defined reporting requirement that applies to when you're opening accounts at the bank. I couldn't underscore more how much more broad the Corporate Transparency Act is and its treatment of beneficial owners. There's not an expectation that a bank or a credit union would need to know when an owner that's not a signer on a business changed addresses or got a new driver's license number. There's the Corporate Transparency Act really goes from something that is tied to, kind of by definition, commerce, opening a bank account, transactions that run through bank accounts. It takes it out of that kind of commerce world and puts it earlier in the process and on every individual with a lot of vagueness. So there are some borrowed terms for what happens with banks when you open up accounts, but this is far, far beyond that. Eric, anything that I missed there that you think would be important to add in?
No, I think that's exactly right. I was about to make essentially the same response, right? Which is that when you're dealing in the world of banking and finance, that's a really neat overlay to the interstate commerce concept and the constitutional tie that makes those types of regulations and laws enforceable, whereas we believe that this is overreaching and not sufficiently anchored to the Commerce Clause.
Great, thanks, Eric. We have a question here. Does the lawsuit only cover members of SBAM with paid membership levels? So we do have a starter membership level where you don't have dues that are paid. Now, it kind of the judge could go a lot of different directions. There might not be a preliminary injunction like was done in Alabama. We hope there is. We've asked for that. But what type of boundaries the judge puts around that, we really don't know. In Alabama, it was pretty explicit. It said dues paying members of the National Small Business Association that was part of the plaintiff class there. That's how that decision came down. We don't know for sure how this decision would happen. Number one, whether or not we'll get a preliminary injunction. Number two, we don't know what kind of boundaries or limitations on that injunction would be made. Now, I think it's important, though, for people to understand that while we're a membership organization and we are taking this action on behalf of our members, our intention is to see this through, to have the law struck down by the United States Supreme Court, and have the Corporate Transparency Act not apply to anybody. But the question here in the meantime is, who would a preliminary injunction apply to? I think maybe I don't know, Stephen or Andrew, if you want to talk about, judges tend to be, I would say it's unusual for a judge to do like a nationwide preliminary injunction or injunction against a law. Would that be? Am I correct in that?
Yeah. Let me just address that briefly. Also timing. So first of all, yeah, you're right, Brian. Nationwide injunctions, that happens when a district court says, look, I'm enjoining this law, this federal regulation or federal statute. I'm going to enjoin it. The federal government can apply it to anybody in the United States. That was happening with some frequency over recent years. Actually, we just got an order from the Supreme Court yesterday in which the Supreme Court reiterated its extreme displeasure with that sort of relief being granted. So what you're more likely to see if there is an injunction granted, it's going to be limited to the plaintiffs in a particular lawsuit, right? And here the plaintiffs is going to be Small Business Association of Michigan, and the SBAM is filing that lawsuit on behalf of its members. So we would expect that if an injunction is granted, it would be for the benefit of SBAM's members as well as the other individual plaintiffs that are in the case. And then in terms of timing, we've requested expedited relief from the district court. We requested a hearing before the 28th, so April 28th. So that's just a week and a half from now. The court may not rule that quickly. It may take a little bit longer, but we do expect that there will be a decision either way from the court within a relatively near term. So to the extent that folks are, to the extent that that factors into folks' calculus, I think that's important to note.
Yeah, excellent. I think, Eric, this would be a good one for you to take because this is relevant under law enforcement, and not actually it is law enforcement underneath the IRS. FinCEN is part of the IRS, but also can be shared with other law enforcement agencies. Is there a statute of limitations on older LLCs that are like shelved entities?
So I wouldn't. It's not really a statute of limitations, but there is an exemption for inactive entities under the CTA. So among the 23 exemptions, there's one fairly narrow exemption for inactive entities. Very difficult to satisfy, in my opinion. You really sincerely must have had no activity, and there's a number of boxes you need to check to satisfy that exemption. But yes, conceivable that you could qualify for that exemption. However, if that entity does take any action or engage in any activity that is disallowed, then it will lose the exemption and come under the CTA again.
And the government's own estimates are that businesses will spend over $5 billion a year complying with this. And I think a lot of that is going to be because of those types of, it's not so cut and dried. Like I've got an entity, I've not used it in a while. Does it qualify for this exemption? In a lot of cases, you're going to need an attorney to help you with that answer. Here's a question of, we've been reticent to file. Should we file regardless to be compliant, hoping that an injunction is to be issued? Here's a couple of things, some thoughts, and I'm going to throw it over to Eric. First is, don't mess around with this one. If you're up against a filing deadline, if you need to file file. Okay, I mean, this comes with heavy penalties. And willful non-compliance is how it's, if you just decide you're not going to do it, you know about it, and you decide you're not going to do it, it can cause you real trouble. However, the reporting requirements are at different times. So if you have a simple situation, you just one business and that business existed before January 1st of this year, you have until the end of this year to make your first filing. So you don't have to do it right now. You could afford to wait, see how this lawsuit plays out, see whether or not the requirement is there in the future. But if you formed a new entity since the beginning of the year, you only have 90 days to file. And so if you filed a business and a new business in January and it's time to file, would not recommend you like take a stand and non-comply and not comply. You should go ahead and satisfy the requirements under the law as they exist today. We're hopeful here, but you should not assume that we're going to win. We wouldn't be doing this if we didn't think there was a good chance that we could win. But nevertheless, you don't want to make this decision based on speculative actions. Eric, what are some thoughts in terms of filing deadlines, some just benchmarks that people ought to keep in mind?
Yeah, that's great, Brian. So exactly right. If your entity already existed before 2024, and you haven't made a filing yet, then you have until the end of this year to make a filing. So if you haven't created a new entity in 2024, you're not in non-compliance, you haven't missed any deadlines at this point. That said, I think it is important to prepare to comply. We don't want to wait until the very end of the year to have to collect all this information in a scenario where the CTA stands or it's amended in some way that makes it effective. So I would recommend people proceed as if they're going to need to report this information to FinCEN before the end of the year, but not actually submit the filing unless they really, for whatever reason, want to get it off their to-do list or just don't particularly care, which is, that's your prerogative, of course. And then for newly formed entities in 2024, definitely watch the calendar. You're right, it's 90 days after formation to submit the filing. And then next year in 2025, that period would shorten to 30 days. So if you're forming new entities or have formed a new entity, I would calendar that. If you're planning to form a new entity and you have the means to do so, I'd recommend talking to an attorney or a similar professional advisor to see if there are ways you can make that new entity exempt. Some of the exemptions could potentially apply. Like if you have an exempt entity already, you might be able to set it up as a subsidiary and get an exemption. So there's some things like that that can be proactive planning to minimize your reporting requirements.
Right. And then, but if, let's say you had a business from last year and you went ahead and filed, so you've already filed, you just wanted to get ahead of it and got it done. At this point, you are obligated to do updates to it.
You are.
So maybe,
yes.
Could you maybe talk just a little bit about what sorts of things would require an update? What sort of time frame would be triggered there?
Yeah, so that's right. If you've already filed, which again, many people did that because it was on their to-do list, and just one thing to get out of the way here, maybe while you're doing your taxes or something, if the information previously reported changes in any way, so keeping in mind that the information you report includes things like residential addresses of your beneficial owners, passport numbers, driver's license numbers, names. So if somebody gets married and their name changes, you are generally responsible for making those updates within 30 days after they occur. So it's important to make sure that your shareholders and even your employees who may not be owners because they have substantial control, so your CEO, your COO, these types of people, even if they don't own any equity, may be included as beneficial owners on your report. You need to track that information because if it changes, that will set off that 30-day reporting requirement. And there are some ways you can streamline that reporting by having a requirement that your beneficial owners, as that term is used in the CTA, obtain FinCEN identifying numbers. That will take some of the onus off the company, because then it becomes the individual's responsibility to keep their individual information up to date. And then the company can just use that FinCEN ID without having to ask for all that information. But that's probably a topic for a different webinar. There are some ways to minimize your ongoing updating requirement if you can do some proactive outreach to your owners and your employees about FinCEN IDs.
Great. So really overarching message here is this is not a one and done filing. You have to make
Yeah.
sure that it stays
It's
up to
not
date.
an annual filing in the sense that you need to do it every year at this time, update it. It's, you know, if you never have a change, then it'll just sit there and you never need to update it, which is, you know, kind of a double-edged sword, right? Because when then any small change you do need to update, and it could be numerous times in 1 year and then not again for several years, and you know, kind of forget about it.
So this question came up: can companies become members of SBAM now and potentially be covered under the ruling of the lawsuit? In Alabama, which is really kind of our benchmark case, it's just what they did have a date when the injunction was granted. The court said anybody who was a member before that date was covered. Anybody who joined after that date wasn't covered. So again, a judge wouldn't necessarily have to do the same thing, but that does seem to be kind of a, you know, there has to be some sort of objective standard on who's in and who's out. And and so that's what happened in Alabama. Not a guarantee that anything like that would happen here, but it's the best that we have to go by. And there's been no preliminary injunction decision. So we just filed the lawsuit. There's been a response that has come in from the government. We'll respond to that response, and then we'll wait on the judge's timing. Okay. So let's take a few more here before we wrap it up. Here's a question just about you'd mentioned the 20 employee and the 5,000 in receipts threshold. How is FinCEN getting information they need from companies that are larger? So if you have, you think about insurance companies, like really big companies. What about somebody who just has 50 employees and 25 million in sales? What is the government in some other way collecting from them?
Yeah, so that's a really perceptive question, right? Because you do have some of these exemptions that are legitimately targeted at companies that have proactive reporting requirements to the government, so public companies, regulated financial institutions. But then you step down from that tier and you've got this exemption for large operating companies or large operating entities. And that presupposes that having more than 20 employees and more than 5 million in gross receipts, whether or not there's another framework for regulation or disclosure, that those measures of size in and of themselves provide an exemption, provide legitimacy such that the government's not going to concern itself with obtaining this information from those companies. So it's a good question, right? You've focused in on the fact that, yeah, there's some companies who are not regulated but are exempt. But if you step below those thresholds, the only thing that's different is maybe I've got a few fewer employees, or I'm not quite at 5 million in gross receipts, but I do have to report. And so that is a spot where, once you cross those thresholds, you're going to be exempt regardless of any other federal disclosure or regulation. But if you're below, you're not exempt. And, there's no good explanation for that other than, I think Congress was saying, once we see an entity achieve a certain size, we're going to assume that maybe there's no money laundering going on or something like this. But it's difficult for small businesses to see that exemption, I would think. and kind of see a slightly larger business not have to report the same types of information that they do.
So if you
Yeah.
do want to launder money, you want to make sure you have at least 20 employees doing it.
Yeah, that's really the ironic thing, is because, as you look at some of the literature on this stuff, they really, the exemptions they focus on is, so, well, here's some exemptions, but it's just the ones you have to report in other ways. It's actually not true. This is really something targeted just at small businesses, smaller small businesses, and like medium-sized businesses who are not regulated they're not subject to the same requirements. So yeah, it really is kind of an interesting, it's just the idea that, that money laundering or other illicit activities are mainly going to be concentrated in smaller businesses. It's a frustrating landscape that they imagined to be the case here. So we've got a question here of as a Chamber of Commerce, somebody watching from a Chamber of Commerce, what should we recommend to member businesses in complying with this? And I'll tell you what SBAM is recommending is that there's no reason to comply earlier than you have to, but when you get to a point where you have reached a reporting requirement, do it. Don't mess around with this. Don't like draw a line in the sand and dare the government to come after you and comply. But if you're not at a compliance deadline yet, there's really no harm in waiting and letting some of this court action play out. But I'm a big calendar person. I like to put reminders on the calendar so that I don't forget things. This would be a great one to put on your calendar to say, okay, well, I don't have any new businesses. My business was formed before 2024. I don't have to report till the end of the year. So maybe sometime around Thanksgiving, you put a notice on your calendar to say, all right, time to make a decision here, time to file.
Brian, I totally agree with that. And the only thing I would add is it may not be easy to get this information from all of your shareholders. I think FinCEN assumes that small businesses are going to have very simple ownership structures, which is not always going to be the case. You may be dealing with people who have not had to provide this information, or you have trusts and you have to explain it to a trustee or somebody's estate or something like this. And so doing some proactive outreach sooner than later to make sure that your shareholders and top employees are aware of it, start to get acclimated to the idea that they're going to need to provide this information at some point, I think is really important, so that you can identify where there may be some tension, if there is going to be any tension with your shareholders.
Let's let this be the last question, and it's like kind of reading through some of the questions online, and it's kind of like one that wasn't directly asked, but I think people are kind of getting at is like, what if you do have a beneficial owner that doesn't want to provide information? Like, who's responsible for that?
So I can give FinCEN's answer, and I think the statute is less clear on this. So Steve, I can kind of I don't know if people can see. I can see Steve's face as I'm about to answer. FinCEN's taken the view that it's kind of everybody's responsibility and everybody's potentially liable, right? Like if the company doesn't report it, then the company's kind of the buck stops there. But if you are an owner and either FinCEN or the company's determined that your information needs to be included and you refuse to provide it, FinCEN's view is that you're responsible as well. Ultimately, you can't send an entity to prison for a willful violation, right? You're not going to put the articles of incorporation in a jail cell. So somebody needs to be responsible for the company, I presume. And so there could be an executive who becomes responsible. So it's not clear to me, and that ties, maybe that's a good way to bring this full circle to the litigation, because that is one of the things I know Steve and Andy are arguing in the litigation.
Well, if I can just jump in on that, Brian. Yeah, I mean, for a statute like this that has a comprehensive sort of thing that applies to small businesses throughout the United States, has felony penalties, is going to create a massive database of information, is supposedly very important to the nation's, national security and money laundering, combating efforts. For a statute that's supposed to do all that, it's remarkably poorly drafted. So one of the things we point out in the lawsuit is it's not even clear. FinCEN says that any individual beneficial owner who refuses to provide information can be prosecuted, and with a felony. But the statute just says that only the entity has to provide the information, and the felony only applies to people who decline to make the disclosure that's required by the statute. So if only the entity is required to make the disclosure, then how can the individual beneficial owners be, felony, prosecuted criminally for something they don't even have to do under the statute? So it's kind of a mess. FinCEN tried to clean it up with the regulations, but has really just made it, worse in some respects, and certainly hasn't cleared it up. And that's one of the things that that we're hopeful that the court will adopt in our argument.
Right. Well, I want to thank you all for your expertise and time on this and handling this important matter. We are going to, for anybody who has some questions here, a couple of things to remind you of. First of all, at SBAM, depending on membership level, there's something called Ask an Expert. I would encourage you to utilize that for specific questions about your business on this issue. And so there are real lawyers behind that service that can review and answer kind of simple, basic questions on your situation. And but also we will go through and respond to your questions there too. Lots more to come on this. We anticipate that we will, over the course of the coming months, do many updates both on the lawsuit, but then also just what we're learning about compliance and posture and experience in the process. So we want you to be well prepared for this and to be able to stay out of trouble. But ultimately, at the end of the day, we're hoping that that we can, through a little help from the United States Supreme Court, get rid of the Corporate Transparency Act. Thank you so much to our guests from Miller Johnson, and thank you for everybody who attended the webinar today. We'll see you next time.
Thank you, Brian. Thanks, everybody.